who believes that what has happened was unnecessary. Kwame Adofo is his name. He's joined us on the line. Council, welcome to Eyewitness News.
Thank you, my brother.
The OSP law is a new creation, so perhaps we are still learning, and there may be errors and there may be things that they will get right. We've seen the court's decision against the OSP on the Sicily-Adapa case, for instance. So it's an office that is being built. It's still an office that is growing, unlike the CID, for instance, which has been there for decades, or the police service. Can they be pardoned? Because you hold the view that the declaration of Ken Ofori-Atta as wanted was wrong. Do you not think they should be pardoned because they are a growing institution or a young institution which is trying to grow?
Well, look, Maro, when you say they should be pardoned, meaning we should accept the mistakes as part of normal day-to-day operations. That's what we should accept it. But where they end up causing damage or reputational damage to an individual, do you just pardon them and just, it's okay, you've made a mistake and that's it, go and say no more? Is that what we are saying? Now, I don't think so. I think an office as serious as the OSP office need to be meticulous. They need to be very, very slow in taking decisions. Now, you read the release today, and he says he has received communications from Ken Ofori-Atta through his lawyers. I think that's what he says. I'm not sure whether Ken Ofori-Atta has himself written to the OSP. I don't know if you can tell me, but
the OSP has actually not stated whether or not it was a direct communication from Ken or it was from his lawyers. But you said that reputational damage. So are you proceeding
before you get there?
Yes.
It is very important that line, whether or not Ken himself has written to the OSP, is very important. The reason is this. On 5 February, there's a letter from the OSP directed to or addressed to Mr. Ken Ofori-Atta. Now, at paragraph 3, he said the OSP does not need or require...
Actually, let me help you. So the second paragraph says, Mr. Ofori-Atta on 18 February 2025 transmitted a communication through his lawyers to the OSP. So I think this is clear.
Does it mean it's his communication or his lawyers have written on his behalf?
What's the point?
Are you following what I'm saying?
I'm trying to get the point.
Yes, communication through his lawyers is different from, say, there's a letter from Ken Ofori-Atta with a cover letter from the lawyers. Two different things. But the whole point is
that consequential though? Either way.
Yes, it is. Yes, it is. The reason is this. On 5 February, there's a letter addressed to Ken Ofori-Atta from the OSP's office. In paragraph 3 of that letter, he says, the OSP does not need or require notification from your lawyers of your arrival date in the jurisdiction. So if you don't need notification from his lawyers, has that situation changed? Has Ken Ofori-Atta now written himself? And therefore, that has given you a basis for you to reverse your decision? Or is just the same lawyers that you refuse their notification previously that have now written to you again and you have accepted? It's so important. Because it was the basis of that you went further to declare Ken Ofori-Atta fugitive from justice, and then subsequently went and declared him wanted. So if you do not need or require the lawyers to notify you of his arrival, the question is, what then changed? That now you have accepted a communication from the same lawyers that you previously said you don't need or require theirs. notification. I hope you are following what I'm saying.
Yes, I'm following you. So you are simply saying that what the OSP said at the time as a reason for declaring him wanted and being a fugitive, at the time it was supposedly a letter or communication from a lawyer which he did not regard, then he should not regard this current letter as well.
Exactly. What has changed? What circumstances existed that has now no longer exist? That's the whole point. You can't, on the basis of lawyers' communication with you and you refusing to acknowledge them, go ahead and declare somebody fugitive from justice, subsequently going on further to declare him wanted. All of a sudden, to do another U-turn on the basis of the same letter that you previously rejected, and come out and say now you have reversed your previous decision. I think that is the point. Okay.
You mentioned that I've got a picture now, but in the earlier submission, you said Ken had suffered reputational damage, and so you believe that he could mount an action, legal action that is. Are you talking about the law on defamation, or you are proceeding on a different law?
Well, look, reputational damage is reputational damage.
And under which of our laws would the former finance minister?
Well, you can sue him for defamation. Why not?
So you're coming under defamation. The reason I asked that question is we do know the elements or ingredients of defamation.
Yeah.
Publication of falsehood against a person to damage their reputation.
Yes.
If a police declares someone wanted and posts their photos on vantage places, just like the OSP has been doing in the past, is that not part of the normal legal procedure to have people report themselves?
If the postage or the posting suggests the guilt of the person they've declared wanted, absolutely.
But it does. Except that it does not. The publication from the OSP has a limitation clause at the bottom, which said that the OSP believes that despite this publication, all persons are innocent until proven guilty by a competent court of jurisdiction. That is.
What are you reading from?
The publication that the OSP put on Twitter, which is now known as X, the one with his photograph declaring him wanted.
What about the first one?
I do not speak to that one. I'm speaking to
the first one said he's a fugitive from justice. You know what that means? Somebody who has been charged with an offense and he's run away, or failing to come to court, and he's now escaped. That's a very serious stuff. You cannot say that one doesn't matter. You are only going for the one that came subsequently. And even that, the second one was even misleading, because it was saying wanted, believed to be hiding, believed to be in the United States or the UK. When in fact you knew that is not true. You have always known that he's in America. So those numbers that you wrote at the bottom of that wanted, if I were to call those numbers and tell you Ken Ofori-Atta is in America, are you saying you don't already know that he's in America?
Okay.
Umar, are you following what
I'm following you, and I would be happy. I would happy if you could indulge me, because I want to ask these questions you're asking of the office. So if you could just stay on the line for me, I want to speak to Sammy Darko. He's a director of communications and strategy at the Office of Special Prosecutor. He's joined us on the line. Mr. Darko, you're welcome to Eyewitness News. The lawyer on the other side, your colleague at the bar, is saying that in the first press conference and the first information you released to the public, you did not take the lawyer's communication to you at face value, and it was one of the reasons you declared Ken Ofori-Atta wanted. Now, this letter of today, or this communication of today, on the second paragraph, you say that Ken Ofori-Atta communicated to you through his lawyers. Did he sign himself this letter as a cover note, or he wrote a letter and the lawyers had a cover note covering that letter? Because his point is that if today's letter is acceptable, then the last week or the previous letter should have been acceptable, and your press conference would have been absolutely needless, and that it amounted to reputational damage.
Your question is very long, but let me try and answer it. I do not know the point from which my colleague on the other side is speaking from. And I said, I do not know the point. I'm yet to hear him point out any legal breaches, so to speak. And I think he has also confused the facts, and in doing that, he may have confused himself. OSP has at every material time acknowledged letters sent by Mr. Ofori-Atta through his lawyers to us. The lawyers always write to us on the instructions of Mr. Ofori-Atta and not on their own accord. I think he's misconstruing something we have said. In the first response to us through his lawyers, the lawyers had indicated that they were willing to assist us with information and the investigations. And the OSP has said that this is a criminal offense. The lawyers could not assist us in that. And we have even said that unless the lawyers were saying that they committed the alleged criminal offense with Mr. Ofori-Atta, then that's fine. Because remember, there's an arrest warrant of Mr. Ofori-Atta. He has to be questioned. People have said that can't you go ahead and prosecute him without him being there and all that? Sender, someone should tell me how you prosecute someone in absentia when you have not charged the person. It's never done. And the things you need from Mr. Ofori-Atta, the lawyers cannot provide. So nobody has ever. And that's why I said that if you confuse the issue, you get your confused answers. Because all that the OSP has said was that you cannot provide the things we need from Mr. Ofori-Atta. It does not mean that the OSP had rejected communication from the lawyers. In fact, yesterday, I do not want to even bring this up. There was a 6-page letter from the lawyers, full of invective, vituperations, insults, threats, and all that. Yes. And today, the same lawyers have written a different letter. And let me state here, and so that he doesn't confuse the issues to your listeners, it's Mr. Ofori-Atta who has written through his lawyers to tell us that he wants to be taken off the wanted list and is now ready to provide us with a definitive date. And he gave us between 14th and 30th May. The SP in his own wisdom has said, I will take the last date, which is the 30th May. And I will agree with you because all this back and forth is because you have refused and or neglected to give us a definitive date within which you attend upon the summons by the OSP. And a fugitive from justice, if I could bring this education up, is someone who is refusing to make himself available to a legal process, be it an arrest, be it a charge from a law enforcement agency. And so when we declare you wanted, it's because it's an inherent power. We have obtained an arrest warrant. We are not finding you. And that is why we publish the wanted notice. And it's a whole process to bring you down. When we publish a wanted notice, it means that you're going to be, we then have to facilitate putting on the Interpol system, and then through Attorney General Foreign Affairs, try and get the law enforcement on the other side to bring you down. And if you remember, the OSP said only two things. He said that Mr. Ofori-Atta has a choice. Either he will voluntarily come down or the OSP will force him to come down. So really, I do not know where people are saying there's a U-turn. Respectfully, there's no U-turn. What has happened is Mr. Ofori-Atta has now acceded to OSP summons and has now given a definitive date by which he will return to Ghana for the processes to continue. Okay. And that he communicated that through his lawyers. So
it means the communication of 18 February is also through his lawyers, not under his signature. I wanted to get that clarified.
Every communication has been through his lawyers to the OSP. Okay. And the OSP has always written back directly to Mr. Ofori-Atta and has copied his lawyers.
Is it the case that...
This is a criminal case. It's not a civil action.
So is it the case that in the past, even though the lawyers wrote to you, which you had no qualms with, your difficulty was that you wanted the person physically and you did not have a specific date given to you by the lawyers as to the date that Ken Ofori-Atta was going to appear before you? That's why you issued that circular.
Our difficulty was that Mr. Ofori-Atta is a suspect of the OSP in a corruption related offences, Mr. Ofori-Atta has been summoned to appear before the OSP. That Mr. Ofori-Atta would have to do that. Your lawyers are at liberty to always come with you and try to ensure that your rights and liberties are protected. That's always allowed.
Did the lawyers at the time
we have always responded to Mr. Ofori-Atta directly and copied his lawyers anytime there's a communication.
Did the lawyers in the previous communication give you a date to say this is the date by which Ken Ofori-Atta was going to appear before you?
I said, Sandra, the whole issue of being declared wanted is because you are unwilling or unable to make yourself available to law enforcement.
I think I understand that. I just wanted a clear, a direct answer to this question.
It's a direct answer I've given you.
I'll ask it again. So my question is,
if Mr. Ofori-Atta had given a definitive date, there will be no need for him writing to us today.
Okay, so in the past he never gave you any date at all.
I'm giving you a definitive date by which I will attend to your summons.
Very well.
And it is important that Mr. Ofori-Atta then requested that he be taken off the wanted list.
Okay.
Let nobody treat this lightly. The OSP is an independent, law-abiding law enforcement agency. When the OSP summons you as a suspect, not just the OSP, be it police, EOCO, national security, it is your duty to attend. If you're unable to attend, you must give very reasonable reasons. For instance, you are either incapacitated, invalid, you cannot travel, nothing of that sort. Law enforcement agencies are reasonable. They will cooperate with you. Or you give them a definitive date by which you think your processes would have been done and you will be available in the Republic. If you're able to do that, there will be no need for a law enforcement agency to declare anyone wanted. If you go to the EOCO website, Ghana Police website, OSC website, several people have been declared wanted just because they've not made themselves available. In fact, some of them are in Usu, but they have not made themselves available to the law enforcement agency. Let's not create anything as if something untoward has been done to anybody who has been invited by a suspect who has been summoned by the OSP. It is a legal process, and you have to go through that legal process. I've even heard some people say, why don't you go outside, you know where he is? Where do we know he is? What is important is that you are needed. And somebody said that, you could do Zoom and everything. I asked myself, you mean you can arrest someone through Zoom? Or you go to United States as they claim he is, or wherever he is, and you effect arrest there.
Okay.
How is that lawful?
That's actually going to be that's actually going to be my question. So, Mr. Adofo,
you can do that.
Let me just ask that. Mr. Adofo on the other line is saying that, in fact, the publication you put out was defamatory. He believes that Ken could sue the office for defamation of character because of reputational damage, and that you knew or ought to have known that he was in the United States, and also you went ahead to publish him as a wanted person, a fugitive of justice. He thought that that was wrong, even though I drew his attention to the fact that a lot of the times law enforcement agencies would publish notices of wanted persons. But he says in this particular case, you defamed Ken Ofori-Atta. What's your reaction to that before we end?
I don't want this to be a banter. It's not about what he thinks. It's about what is lawful. That's why I said that he should, if he's able to point out what is unlawful, of course, every citizen is within his right to go to the law court and vindicate whatever position he has. But what I can say is that inherent in the law enforcement agencies is the power to arrest and to declare a person wanted when they have an arrest warrant for such a person. If someone wants to challenge that in court, the person can do so. People are at liberty. But what I think was right is to let Ghanaians know that everybody, irrespective of who you are, high or low, when you are needed for an offense, there are always ways that are done. Sometimes you are lucky the law enforcement agency will call you and tell you that you are needed here. That's why we have always said that there's an arrest without a warrant and there's arrest with warrant. And the law enforcement agency under Section 10 of Act 30 has reasonable grounds to believe you've committed an offense. They can arrest you without a warrant. If you are not within the jurisdiction or they cannot locate you, they will typically go for an arrest warrant so that it can be served, especially to other people or other agencies, so that when they see you, they can arrest you and then bring you to that law enforcement agency. And if it's outside, you go through the Interpol system, You go through Ministry of Foreign Affairs, Attorney General to procure the presence of the person. The OSP has acted lawfully. The OSP has not breached anybody's rights or liberties. The OSP has been very fair. And you notice that just as Mr. Ofori-Atta has now acceded to OSP summon and has agreed to come and has indicated to us a specific date by which he will make himself available, the OSP has acceded to his request. And to the extent that the OSP has acceded to the request, what is the point of keeping him on a wanted notice?
Very well.
That's why we have given the caution. If the time he himself, Somutu, has provided to us through his lawyers, he is unable to fulfill it, the whole process will be revisited.
Very well. Okay. Thank you. Thank you so much for speaking to us, sir.
You're welcome.
That's Sammy Darko. He is Director of Communication and Strategy of the Office of Special Prosecutor. Let me conclude with Kwame Adofo. He is private legal practitioner. Mr. Adofo, he says what they did, they acted within the law, and it is the procedure as prescribed and is inherent in their law. And so he does not see any defamation or any breach of personal liberties whatsoever. And he has also explained the other issues about the letters from the lawyers and why this one is valid and not the previous ones.
Umaru. Hello.
I'm listening to you.
Yeah, Umaru. In fact, I did not hear the conversation between you and him, so I don't know exactly what he said. Unless you are able to tell me what he said in relation to my points, then I can address them. But I did not get the answer whether Ken Ofori-Atta actually personally wrote to them again, or
forgive me. I was under the assumption that you were actually hearing him, because he said that one, Ken Ofori-Atta wrote through his lawyers to the office and requested that he should be taken off the wanted list and also not be declared a fugitive, and also gave a date within a range in May, ending in 30th May, by which he plans to come to the office. And they have chosen the latest or the latter day, which is the 30th, and they expect him to appear before their office. If he fails, they will then put him back on the wanted list. And he said that even though lawyers can write for and on behalf of clients, in the case in the past, they wanted Ken Ofori-Atta to attend upon the office, which he failed to do in person, and that the lawyers and even Ken himself has never given them a date in the past by which date he was going to appear before them. That's why they saw need to put him on the wanted list. And then on the issue of defamation, he says they had an inherent power under their law to declare persons wanted if the persons fail to appear. And he mentions at Act 30, in which act we have discretionary power for law enforcement agencies. If you explain to them that you're unable to appear because of incapacitation or any other challenge that you may have, they would use their discretion, of course, reasonably, to determine that you do not have to appear. But in that instant case, or this instant case, they didn't think that his justification was enough, and that is why they had to put out that flyer. But they have since rescinded that and are waiting him by 30th.
Look, Umaru, in relation to the first point, that Ken Ofori-Atta's lawyers did not give him any definite time for his arrival, or definite date for his arrival, let me refer you to a letter that I have a copy on the 7th of February, written to Mr. Kisejapin by the lawyers of Ken Ofori-Atta. Now, and it was receipted at his office on the 10th of February, 2025. It says direction to attend the office of a special prosecutor, further to our letter dated 31 January 2025, and response to yours dated 5 February 2025. We write our solicitors for Ken Ofori-Atta in respect of the above subject, which was addressed to our client and which we were copied. Please find attached here to a document indicating that our client is receiving medical attention at Mayo Clinic in the United States, detailing his appointment and timeline, suggestive of a post-March date when our client may be able to be,
Are you done with the parts that you're reading?
I'm sorry?
I think I lost you briefly, but so the date mentioned in there is post-March. What is post-March, or what date is post-March?
Post-March. Post-March is post-March. He didn't say...
Post-March can be April. December.
Well, but post-March, and did they find out post-March, what day exactly in post-March did they say he's coming?
Yeah, but the OSP says they needed you physically, and you have to give a reasonable explanation as to why you cannot be there. But if you write a letter and say you would be available post-March means after March, and after March could be December. They thought that they needn't go through that process, so they had to put a flyer out. Wait,
the reasonable explanation is the medical report that was included. Are you saying that it was not so reasonable for you to for you to at least acknowledge the presence of a medical report? Is that what he's saying? I wish I had heard him directly, then I could understand exactly what his point was. It looks like now we are talking through you, and I don't really know exactly what he said.
Very well.
The point is, they were cooperative to the extent that it was not even necessary for the OSP to have gone further to declare him a fugitive from justice. That is the point I'm trying to make. It was not necessary.
Very well. I get you. Thank you. Thank you so much for speaking to us, sir.
You're always welcome.
That's Kwame Adofo. He's a private legal practitioner speaking to us on the Ofori-Atta matter. This is Eyewitness News on 97.3.